Welcome back to the League of Women Voters Education Fund Houston and Texas Conversation with the Candidates. We're now going to talk to candidates for the Harris County District Attorney's Office. We want to remind folks at home that all of the candidates on the ballot were invited, and those who you see tonight actually took us up on the offer. Our first candidate is Ms. Kim Ogg. Why are you running for District Attorney?
Darrell, I'm Kim Ogg. I'm a native Houstonian. I've been a lawyer 27 years. My mother was a kidnap victim, and I want to make Harris County safer.
Yeah, I wanted, since we have an hour here, I'd like to take a little bit of time, if you don't mind, and tell the voters about some important dates that are coming up and give a little pitch to the League of Women Voters and some other telephone numbers that would be helpful.
Great.
And also a correction here, Ms. Ogg is the only candidate here this evening. First of all, if you have any questions, there are a couple of websites you can check. One is lwvhouston.org. That's the League of Women Voters website. Our telephone number is 713-784-2923. Another is the Harris County Clerk's Office, and that website is www.harrisvotes.org. Telephone number is 713-755-6965. For those of you who are just junkies and hanging out and watching the Harris County District Attorney's race and you don't live in Harris County, then you might want to check with the Secretary of State's office, and their website is www.votetexas.gov. Their telephone number is 1-800-252-VOTE. The first day for early voting is next Monday, the 20th. The last day to apply for your ballot by mail is Friday, the 24th. The last day of early voting is Halloween, Friday, the 31st. And the last day to receive your ballot by mail is Tuesday, November 4th. And that means, what I meant when I said that is that needs to be received by the county clerk's office by mail. It has to be there by 7 o'clock that day by mail. That is also the day of the general election. During early voting, you can vote at any polling location in Harris County, but on election day, you must vote at the polling location where you are registered to vote. And now that I've taken all that time, I do have a question for you.
Right.
So I would like to ask you one of our League of Women Voters guide questions, since you had so much space to answer there. What do you believe are the three most important issues currently facing the District Attorney's Office, and how will you address them?
Well, use of resources. Right now, most of our resources are being spent on on people in possession of small amounts of drugs. I would like to reverse the priorities and spend most of the resources on violent and high-dollar property criminals. Two, we have a grand jury system that's in need of reform. Many people feel disenfranchised and distrustful of the system because they don't believe that people get a fair shake when they go in front of the grand jury, or that certain people get a pass when they go in front of the grand jury. And third, management. Technology is woefully behind in the current district attorney's administration, and I'd like to revolutionize through technology how the largest public law firm in the South and Southwest is managed. We recently saw a case where an individual was, quote, lost in the county jail. A good management system would prevent that. He was a mentally ill defendant, trapped, really jailed for several months in a cell that was beyond description. And so I think a good case management system would have easily prevented that from happening.
Darrell, I'd like to segue into another voter's guide question, since she talked about something earlier. What do you think are the appropriate boundaries between prosecutors and the grand jury? And what steps would you take to ensure that all the members of your staff observe these boundaries?
Well, the grand jury is a constitutionally guaranteed right when you're charged with a felony. You're supposed to be brought, your case is supposed to be brought before a body of peers to ascertain whether criminal charges should have been filed in the first place. It's a probable cause test. Was there evidence, was there probable cause to believe that you committed a crime? The prosecutor is the only party representative, advocate, allowed in. Defense lawyers aren't allowed into the grand jury. And so it's an immediate advantage for the state. The prosecutor represents the people, and yet the grand jurors are also reflective of the people. And so the appropriate boundary is, I think, in use of sound evidence that's presented to the grand jury. There shouldn't be any leaps of faith. Right now, we wait at least 60, 80, sometimes more than 90 days for drug test results. Grand juries are asked to act anyway. At times, I think that's inappropriate. And when a prosecutor possesses information that might show that the defendant or the accused could be innocent, they're supposed to disclose it to the defense lawyer and the defendant. That information should be disclosed to the grand jury as well, so that the group reviewing whether charges were correctly brought has enough information to make an informed decision.
Oh, that's interesting. I would have thought that that would be routine. So it's not required that they...
There's not a check and balance.
I see.
The Supreme Court of the United States has said that prosecutors need to disclose evidence that might tend to show the innocence of the accused. But we see prosecutorial misconduct from the U.S. Attorney's Office in the case of the Alaskan senator, to the case of the police officers in New Orleans, recently convicted and then overturned, their conviction overturned. They shot a fellow coming across the bridge after Katrina. It was a civil rights case. And prosecutorial misconduct, we've seen it in the Michael Morton case. So it's common, unfortunately. I'm not suggesting that it's the rule here. It's certainly the exception. But there's not a check and balance in the grand jury. And I just want to make sure that our prosecutors share the values that the Supreme Court has made clear we're to follow. Because our duty as prosecutors is not just to convict, but to ensure that justice is done.
Thank you, Darrell.
I'll go to another League of Women Voters Guide question. How will you address the issues surrounding the sentencing of nonviolent offenders in order to ensure that the penalty appropriately reflects the severity of the offense?
I've proposed for misdemeanor marijuana offenders that we cite and summon them to court, meaning they would not go to jail. This would also avoid bail, an expense that some people just can't afford. That keeps them in jail, and sometimes people plead guilty for economic reasons, which is not the intended result. Third, when they get to court, and they have to come to court, or a warrant will be issued. When they come to court, I plan to offer a plea bargain that allows them to work for 2 days performing community service, cleaning our bios. I'm a big green, an advocate of the outdoors. I want our environment cleaned up. It's interesting, nobody claims the garbage in the ship channel. The channel is the ports, the banks are the flood control district, but nobody claims the garbage. So I'm going to claim the garbage, and we're going to have misdemeanor marijuana offenders clean it up. That'll save us about $10 million a year. It'll also give them the opportunity through this program I call GRACE to keep their criminal record clean. It won't be instantaneous. They'll still have to either hire a lawyer or by themselves apply for their record to be expunged, but it will be a case that's dismissed that will allow them to have a clean record. Right now, we're crippling our workforce. We're saddling young, mostly minority, mostly male, mostly poor people with criminal records that are in essence a life sentence. I want to avoid that. And yet when it comes to serious criminals, I told you my mother was a crime victim. I think we're in the middle of a burglary epidemic. I propose no probation, for example, for burglars, unless a jury wants to give it to them.
A couple of years ago, there was a bill in 2011 on the House floor that would have allowed basically automatic early release for first-time non-violent offenders, non-3G offenders in TDCJ, to be able to automatically make parole with good behavior, and if it was their first non-violent offender. A lot of the different DA's offices lobbied against that bill. What are your thoughts there?
I think that our Texas County and District Attorneys Association is clinging to draconian ideas from the 80s that their job is to mandate punishment as stiff as possible. I propose a new kind of a cultural growth among prosecutors, and I find it to be welcomed by many prosecutors and certainly by the public at large. Nonviolent offenders need to be reintroduced into the workforce better than they went into jail. This cradle to prison pipeline is damaging to our economy, and the human toll is tragic. So I'm surprised, I guess I'm not surprised, that it didn't pass, and perhaps not surprised that certain district attorneys lobbied against it, but I can tell you I'm for it.
Thank you.
I'd like to go back to your plan earlier regarding marijuana. That was regarding possession cases of less than 4 ounces, correct?
Yes.
Would that also apply to other classes of drugs?
Not yet. I've only proposed grace as the future of misdemeanor marijuana prosecution in Harris County. There are other misdemeanor drugs, possession of a Valium pill, and other Schedule IV drugs that aren't penitentiary punishable. But I think that marijuana is, by and large, I've looked at the stats. For example, in 2013, there were about 12,600 people arrested for Class A and B misdemeanor drug possession cases. 12,000 were marijuana. The other 600 or so, other Schedule IV drugs, like I said, Valium, a small amount of it. I think that that will be the next area that we move to, and then later to crack under a gram or cocaine under a gram and other scheduled drugs. But I want to make sure this marijuana program succeeds. The public is embracing the program. You can see nationally a real trend toward having an adult view of marijuana, treating it more like alcohol. I'm not pushing legalization or even decriminalization. I'm certainly not saying it's okay to get high and drive. But I am saying that the disproportionate enforcement of drug offenses, especially marijuana, is putting more black and brown young men in jail than white individuals, and that disparity is creating a perception that the system is racist, and I think it hurts the trust of the community, not just the African American community or the Latino community, but all communities, that our system really isn't fair, when what it is an uneven application of law.
Thank you. Moving over to the law enforcement side of this program, I understand that that it should keep officers off the street, but they still have to tag the evidence and write a report.
They do.
So, tell us more about how how that would be shortening their time off of the streets.
Great.
While they're taking care of this.
The GRACE program, the future of misdemeanor marijuana prosecution, I've said will keep officers on the street about 3 hours more, because every arrest requires a transport and then tagging the evidence and writing a report. The evidence can be submitted at the end of a shift if an arrest doesn't have to be made. An offense report can be written right there at the time that the stop is made and the cite or summons is issued to the offender. And it doesn't take very long to describe a marijuana arrest. There's going to be probable cause, perhaps a traffic stop, maybe a stop and frisk on the street, but generally nothing too complex. An officer can easily write that at that time or wait till the end of the shift. And it keeps the officer on the street on parole. I just met with residents in Montrose who are angry about the number of burglaries. They say they just don't see many police cars. When they do, they don't always get a response that they find very service-oriented. I hear people saying police won't take fingerprints at the scene. So I want to make sure that our law enforcement officers are equipped with what they need to gather evidence appropriately, and that they stay out on the street on patrol.
Just one letter.
Yeah, just one letter. Big difference.
In your opinion, would odor be considered a reason for probable cause?
It's used all the time. Officers will report that they smelled the odor of burned marijuana and sometimes crack cocaine. That has been found by our Supreme Court to be sufficient. Now, it's not something that can be tested because odor is dissipating from the minute, I guess, it's in the air. So it requires testimony from a police officer. The credibility of that police officer witness is what a judge or a jury ascertains in deciding somebody's probable cause or guilt.
How would you handle trace cases?
Differently than my opponent. Right now, my opponent is taking any kind of case where an instrument like a crack pipe or any kind of drug paraphernalia tests positive for cocaine. Let me say, I think that where there's not enough of a substance to permit both sides to test, and that requires 5 tests. A field test, then the government gets a test, and then they confirm with the second test. The defense should be entitled to equal testing. Where they're not, I firmly believe that that violates a person's due process rights. They should get to contest that test with their own test. So I'm not going to take crack cocaine cases where a suspect's mouth is swabbed or where there's not enough drug to test.
Thank you. Darrell?
I'm going to go back to the list of questions. What would you do to a prosecutor who knowingly suppressed evidence and used false testimony, and would you support making such conduct a criminal offense?
I'd fire them, and it is a criminal offense in certain instances if they perjure themselves, or if they tamper with documents. We lawyers are officers of the court. We're held to an ethical duty by our state bar when we take the oath to practice law. More importantly, we're public servants. We owe the public the trust that they've instilled in us as their elected official, as the DA, and as the attorneys who work for the DA. And so anybody who knowingly used false evidence would likely be charged with a crime. They would certainly be investigated. Unfortunately, we have an example of that right now in our district attorney's office. There was a fellow, Ruben Sean Carrizal, a police officer, investigator at the DA's office, found to have backdated a search warrant in a murder case. He was not fired. He was allowed to resign. He was not prosecuted for tampering with a government document, nor even investigated. I find that unacceptable. It tells the public there's a double standard, one for friends or employees of the DA and the system, and one for everybody else. It's not fair. It destroys people's trust and their faith in our justice system. And you know, when that goes, we've got real problems in this democracy.
This is a similar question. It may be almost exactly the same. In the last session of the legislature, the Michael Morton Act was passed, and that requires that the prosecution turn over everything to the defense. Do you support this act, and what should be the sanction for failure to follow it by a prosecutor?
I absolutely support the Michael Morton Act. Michael Morton spent 25 years in a Texas penitentiary for a murder he did not commit. Equally horrifying, the real murderer was free during those 25 years, and he murdered again. This was caused by Ken Anderson, the prosecutor, elected DA of Williamson County. John Bradley, unfortunately, fought testing. John was Ken's successor, and he fought testing of the bloody bandana, a bloody bandana, found near the Morton home immediately following the murders. That bandana ended up containing DNA evidence from a serial rapist and murderer who was eventually caught and prosecuted for the murder of Mrs. Morton. Ken Anderson failed to turn over many important pieces of evidence in the murder file. This bill is designed to force prosecutors to do so. Anderson then lied about knowing that those pieces of evidence existed and withholding them from the defense. This is not just insult to injury, this is a crime. And he did 10 days and has now been disbarred for it. The question is really quite different than a cop who backdates a search warrant. That's manipulating evidence to gain a result, withholding evidence that would show there might be another suspect out there. And in this case, there was. The other suspect had used the victim's credit card. The other suspect had left the bloody bandana outside the Morton home. The other suspect had committed the murder in front of Mr. and Mrs. Morton's child, who gave a statement saying that his daddy was not home when the monster, as he called him, killed his mother. This type of withholding is prohibited by the Supreme Court in a case called Brady versus Maryland. We call exculpatory, or evidence that would tend to show the innocence of the victim, Brady material. Officers who lie are often referred to as people who should be on a Brady list. So this reference to the case about prosecutorial misconduct by withholding evidence is critical to the very oath that prosecutors take, which is to see that justice is done, not just to seek a conviction. So we will have a Brady list. Right now, our Harris County DA sends out emails, she says, to prosecutors about officers who are caught lying, like Ruben Sean Carrizal, backdating the search warrant. Well, what happens when the person who receives the email moves to a different court, leaves the office, forgets, is reassigned? There has to be a permanent record for all prosecutors to turn to and then to turn over to the defense when somebody lies. And if they withhold evidence, they have to go on a Brady list. So this goes right to the heart of justice, and we can't, as a community, accept that it's enough that people that my opponent says she's doing, everything she can about it. She's not. We have to do better than that. We have to have a policy, a system, and then we have to act on it. And I will.
Thank you. Darrell?
You talked about the Brady list. What are some other innovations you think could bring or make it easier to manage the Harris County District Attorney's Office?
Well, our District Attorney's Office uses a very antiquated paper system. We can go paperless probably within a 2-year period if we implement a case management system. Right now, the largest public law firm in the Southwest, the Harris County DA's office, has no case management system. Imagine trying to run a law firm. I can't imagine it. Now, I worked at the DA's office for 7 years in the late 80s and early 90s, before such technology was readily available, although case management systems are not anything new. It's only the technology that's been revolutionized. So I think that will bring a great change in terms of organization, not losing people in the system. We can hold our prosecutors accountable. We'll be able to know how much time they spend on certain types of cases, on certain cases themselves. whether the time they spend was worth the taxpayer dollar expended to prosecute that person. And we can hold ourselves accountable by providing that information to the public, who can then grade our paper. I don't believe in withholding evidence of efficiency and effectiveness. If it's not good, we need to improve it.
How are you going to ensure diversity in the district attorney's office?
Through hiring. We right now have a district attorney's office that is not reflective of the community. It's mostly Caucasian, it's a little more female than male, it's mostly young. We need a district attorney's office that has a breadth of experience. So one, we're going to hire some older lawyers, more experienced people, especially with regard to white-collar fraud. We need some litigators who understand how to chase paper. Young people coming straight out of the law schools rarely have had business experience or prior commercial law experience. I think when it comes to white-collar crime, it's imperative we have lawyers who really understand how to utilize discovery. And a grand jury subpoena is virtually discovery, you know, to the 10th power. You can get everything you want without having to fight for it. We're also going to ensure that the international communities, Indo-American, Chinese, Thai, Vietnamese, and of course African American and Latino populations are more fairly represented. We won't be able to do it all at once. That's not what I contemplate, but we're going to have a more diverse DA's office, and it's going to be diverse not just in race, but age, gender, sexual orientation, and religion, because that's Houston. We're the most diverse county in the country, but our DA's office at times looks like it's just too monochromatic.
Thank you. Darrell, can I cut in?
Sure.
You were talking about hiring older lawyers who are more experienced to deal with white-collar crime. I think that when most people think about the district attorney's office, they think of more violent crimes or drug-related crimes. Could you tell us more about white-collar crime and what your plans are to deal with white-collar crime?
Criminals who commit crimes with pens instead of guns can do a tremendous amount of damage to a victim. And while an individual is certainly thought of as a crime victim, businesses, we forget, can be crime victims too. Businesses are employers and employees, people. So when a business is victimized, people lose their jobs sometimes. So I propose a service-friendly attitude that accepts white-collar cases as important crimes, that doesn't have a tiny division of 3 or 4 lawyers assigned to it, but is robustly staffed, where white-collar victims, businesses, are invited to bring crimes that occur. Our police departments just don't have the resources to investigate white-collar crime. That's clear. If you get hit on the head at an ATM machine, 5 cop cars show up. If your secretary embezzles $5 million, good luck. You're going to get the same offense report style notation that a police officer gives an aggravated robbery victim. And yet, it's very difficult to get those cases investigated, even though many times the white-collar theft isn't complex. It's just a crime committed on paper. So I think it's important to, one, acknowledge that small businesses and large businesses can be crime victims. 2, that we adequately staff that division. 3, that we welcome those cases. Right now, the most common thing you'll hear from the Harris County DA's office is, oh, that's a civil matter, especially if it involves somebody who works at a business. Well, theft is not a civil matter, nor is trade secret theft, nor is intentional destruction of a computer system, a customer database, nor is identity theft. So the crimes of the 21st century, which are much more paper-oriented than ever before, not paper-oriented, but are not violent, more so than ever before, are largely ignored by the Harris County DA's office. We're going to change that. Our businesses need to know that they have a resource in the DA.
Thank you. Darrell?
Why are you more qualified than your opponent?
I have a very diverse background. I'm from Houston. I'm a native. I know the people. I know the county. I've lived in many of the neighborhoods around town. And I understand the problems that people face because for the last 27 years, I've been out working in the community. After I was a prosecutor, I ran the anti-gang task force. I went to civic club meetings, schools, churches, because the gang problem had many fronts, and it was clear that we needed the assistance of everyone. Then I went to Crime Stoppers and ran that. It's a small business. It's a nonprofit, but in essence, a nonprofit is a small business. Had a board of 40 different members, and we ran the most successful crime tips hotline in the world. It was back to casework. I enjoyed capturing, not me personally, but soliciting the public and running a anonymous crime tips hotline that we raised cash rewards for to help police solve crimes on a case-by-case basis. So I've worked in prosecution, public policy, and running a business. Now I'm in private practice, and I represent people in civil rights actions, family cases, and criminal defense. Crimes affect people at all different levels, and the response is not simply to say we're tough on crime. It requires a nuanced, strategic plan that the chief law enforcement and criminal justice agent of the county, the DA, leads, and leads from the front. And so I just think I have the experience, the qualifications, and finally, the judgment, which I don't think can be inherited or appointed. My judgment comes from the School of Hard Knocks. I certainly have not always been a perfect person or had everything go my way. I've not only been a prosecutor or a judge. I've had many different experiences. And so I feel that I'm compassionate towards both victims and people accused of crimes because everybody deserves a fair shake. So I want to bring that experience and my lifetime of professional activities, programs that have both succeeded and failed, bring that knowledge to this job and help our county tackle the biggest and most challenging responsibility of government, public safety. I think I can do it.
I want to talk about bail in Harris County.
Mm-hmm.
I've read that we have probably the highest bail in the state of Texas. And consequentially, that puts people who have been historically marginalized throughout their lives in situations where they are in jail up until their trial. Is there anything that you would do as district attorney to change that policy? Is it possible for you to even do that? Or is there something that you might recommend?
It is absolutely possible for the district attorney to affect the bail schedule. Judges said it, but it's no coincidence that my opponent is heavily supported by the bail bond industry. I'm not. Why? We have a pretrial services division paid for by taxpayers, well-staffed, that are specialists at risk assessment. The purpose of bail is to secure the person's reappearance in court. It is not supposed to be a tool by which we force plea bargains by keeping the poor in jail until they plead guilty. Judges right now will turn to a prosecutor at the time that the accused is first in front of them and bail is set. Pretrial division will come in, give their risk assessment, and sometimes recommend a pretrial bond, which is in essence a personal recognizance bond. We used to call them PR bonds, meaning promise to return. If you don't, a warrant will issue. most people return. Our district attorney's office, in every case, routinely opposes the recommendation of the pretrial bond division, despite their expertise, despite the resources being spent on the assessment. The DA's office says we have a policy against it. I've often asked prosecutors, why? Why do you oppose this person's pretrial bond recommendation? They're native, they live here, have no prior record, or have a minor record. We know where to find them, and they're going to come back to court. And many times it seems that the people who are representing the DA are just doing it by rote. They haven't been told the reason. There isn't a reason that really correlates to the purpose of bail. I want to give prosecutors the discretion to agree with the pretrial service assessment when they think it's appropriate. It may not be appropriate. If there's evidence that the person may flee, has something in their background that makes them a threat to the community, then the prosecutor rightfully should oppose the pretrial bond, but that's going to be reflected in the assessment to begin with. So we can affect the schedule by encouraging judges to set a reasonable bond schedule. We can encourage prosecutors to use their autonomy and good judgment to make their own decision about the pretrial assessment and whether it's appropriate or not. And third, the DA can be independent from the bonding industry, who makes millions by having judges deny pretrial bonds on the basis of the prosecutor's recommendation, forcing that person to either get a surety bond, put up the cash, or stay in jail. It hurts the economically disadvantaged. It's unfair to the poor, and that's discriminatory, and we're going to stop that.
Thank you.
You spoke earlier about some citizens, for economic reasons, taking plea bargains. Could you elaborate on that?
Sure. When a person goes to jail, let's say for marijuana, misdemeanor marijuana, the average time they spend is 5 days. Their car's impounded. It's picking up fees right at the storage lot. Their children may get sent to CPS if there's not a relative to go get them or take care of them. They may lose their job. Somebody doesn't come to work for 5 days, it's likely their employer's going to fire them. It's at least possible. If you're too poor to put up a cash bond, and you can't even make a surety bond through a bondsman, and the judge denies you a pretrial bond, even where it's recommended, then you're basically being punished before you've been found guilty by being kept in jail.
Because you're poor.
Because you're poor. Our Constitution and the Supreme Court of the United States says that's unconstitutional, and I'm not going to do that. We're just not going to let that happen.
Have you always known you wanted to be district attorney?
No, I have not always known that I wanted to be district attorney. When I was in college, I majored in journalism. I worked for a newspaper. I've had other different jobs. I've even worked in the service industry, in restaurants. So I have a very ordinary background. My father, however, was a state senator, and my mother and he contributed a big part of their lives to public service. I do believe that it's our responsibility and that we get great reward from serving others. So when I went to the district attorney's office, I intended to only stay for my initial commitment of 3 years. But I loved the job, and I loved helping crime victims. I enjoyed helping people accused. I thought that the pursuit of justice was worthy. And I stayed 7 years, and I surprised myself. And then instead of going into the private sector like I'd intended to go make more money, I went into work at City Hall, being appointed by Bob Lanier as the Anti-Gang Task Force Director. From there, I went to Crime Stoppers. So I think public service is in my blood. I will tell you that when our elected DA passed away 13 months ago, I picked up the phone, I talked to my family, and I went to see my brother. I couldn't get him on the phone. to let him know what I was going to do. When he answered the door, he said, "Don't say anything." And he handed me a piece of paper, and I opened it up, and it said, "Run for DA." So I've told my family all along that I wanted to, that I thought this job could be done well and that I was qualified to do it. But I didn't know I was going to get the opportunity because, of course, none of us knew that the elected DA would pass away. So when that tragedy happened and the position presented itself, it did seem to me that all roads lead to Rome, that all my career has helped me build for this moment to go help my city and to be a DA for all people that accused and crime victims alike trust to do the right thing.
Thank you.
Ms. Ogg, you seem very, very passionate about the pipeline of prison, and that's something that that's a passion of mine as well. I used to work for the prison system, and while working there, that's where it opened my eyes to a lot of different situations. Where in your background did this passion come from?
Teachers were really important in my life. They were good role models. And as you know, having worked in the penitentiary, many people cannot read. When you can't read, you fall behind in school. You start hanging out with the crowd that compensates, especially if you're a young man, but also if you're a young woman. You get into a lot of things earlier, maybe that then lead to teenage pregnancy, and they're life-changing events. Guys are drawn to gangs, the short money, the lure of this pseudo-family environment, when of course it's just the opposite. It's just criminal organizations using young people to make money. So the passion against stopping this, or for stopping the cradle to prison pipeline comes from me having had the opportunity to learn to read. I had good teachers. I had parents that helped me. I wasn't economically disadvantaged, although my parents certainly in public service weren't wealthy people. And so I just feel like everybody ought to get that same opportunity, but I know that they don't. So crime prevention programs, youth programs, after-school programs, we got to invest in this. Otherwise, we catch it on the back end. And once we start incarcerating a person, giving them a criminal record, it makes it increasingly difficult for them to enter into society and act like a responsible person. So I just want to make people better taxpayers than criminals. When we throw offenders who have a joint into the same cell that a murderer or a rapist is in, that just can't be a good idea. And I want to end that. And the one position that makes it all possible is district attorney, because we're the architect of public safety policy for the entire county, and it rests in this one position. So it's the opportunity of a lifetime.
I know the district attorney's office can help the victims, and I have been a victim of a crime. When the crime was committed, though, it was not a crime. And legislation was passed probably a year later. And when I approached the police department in the town that I lived in, I was greeted with questions as if I had done something to cause that crime to happen. What would you do in the district attorney's office to make crime victims feel more comfortable in coming to you? And how would you help victims of crime as they're going through the entire process?
I have been a lifetime advocate for crime victims. I've received some national awards and things that really just sound like I'm tooting my own horn. Let me say my mom was a kidnap victim. 1963, kidnapped in front of a bank building in downtown Houston, forced into her own car at knife point, driven down Main Street, and told by the serial rapist exactly what he was going to do and how he was going to kill her. She made the decision to jump out of the car. Later, after she'd had chemotherapy and lost her hair, the scar was visible on the back of her head, a big scar. Mom never complained. She never whined about what happened. She never felt sorry for herself. But she and my dad set out to make a difference. I think that crime victims carry scars that we don't see around with them for their entire lives. And that crime affects not just them, but their family, their loved ones. At our DA's office, we have a victim witness division, crime victims' rights division. However, we've had district attorneys that don't listen to what the crime victims want to happen in their cases. They'll seek a certain result. Sometimes it's merciful, sometimes it's harsh. I think the DAs need to be sensitive to the desire of the crime victim and the result that they want. I don't have to promise crime victims we'll do what you ask every time, but I'm going to listen to you. Technology plays a role here. Individuals who murder, we invest a lot in Harris County in getting them arrested, prosecuting them, and yet after they're caught, often the public never hears anything else about the murderer or the crime. I'm going to create a website that simply tells the public when those individuals are going to be paroled or when they're up for parole, so that the victims who now have the burden of informing our prison system where they live, so that the prison system can send out notice. It's a very antiquated snail mail system. I'm going to post the information so that victims and the family members of the murderers, should they desire, and the public know when these individuals are coming up for parole. In one case that we solved, two of the murders were caught through Crime Stoppers. My friends Carrie and Lou Ruiz, their daughter was murdered on Halloween by a Latin king and two accomplices. He fled. The main murderer, the guy who stabbed their daughter 30 times, he fled to Venezuela. Under Chuck Rosenthal's regime, my friends tracked down the murderer, knew he was in Venezuela, and asked Rosenthal, the then DA, to go ahead and allow him to be extradited. It would have required Rosenthal to agree to a maximum 30-year prosecution. My friends, Lou and Carrie Ruiz, agreed to that. They wanted him punished. They wanted the murderer here in prison. Rosenthal refused, saying he had a policy that he didn't negotiate with other countries in terms of extraditing by promising them a cap on the plea bargain. That's ridiculous. Their daughter was murdered. It was their right to have that murderer extradited. If they wanted him to make that deal, he should have listened to them. I'll listen to you.
Thank you.
If you weren't running for district attorney, what other spot on the ballot would you place your name?
There isn't
this time
one.
around? Huh.
There isn't one. I am not in the market to be a judge or a senator or the dog catcher. I'm in the business of public safety. The district attorney's spot is the apex of public safety power to change our system. Right now, we chew people up, we spit them out, we make them unjob worthy, unhireable, unhousable for the most minor of offenses at the expense of very dangerous people among us who intentionally hurt people. We have to change that. It's 2014. I've been in this business 27 years. I just see it getting less effective. And all we need is a little bit of out-of-the-box thinking, some reasonable expectations by the public, because there is no magic bullet, some patience, some flexibility, and some leadership.
I've got a wild card question here. Say something nice about your opponent.
Miss Anderson has taken the district attorney's office at a very difficult, taken charge of it at a very difficult time in her personal life after the death of her husband. I commend her for taking care and responsibility for the office. And I want to thank her for that.
Thank you, Darrell.
I guess I would ask, along that same vein, what's one thing that you can say you agree with her on? What's one belief in the campaign trail that you say you agree with her on?
Well, originally, after Mr. Obama said that he had smoked marijuana in his youth and come out and made some grown-up statements about the impact of marijuana being similar to alcohol, my opponent really went draconian on him and said, we're going to prosecute every drug user to the max. I came out with my GRACE program saying no jail, no bail, no permanent criminal record for misdemeanor marijuana offenders if they earn it through 2 days of community service. I heard that day for the first time that my opponent said she'd been working on a program like that. And she said she'd been working on it for some time. Now, in one breath, I thank her for taking the DA's office at a difficult time in her life. On the other hand, she's had 13 months. She just implemented her own marijuana program. But it seems unconstitutional for me. There's no jail if you're a first offender, if it's HPD or the sheriff's office that arrests you, if. The cop is still off the street for several hours. And I don't see how a person arrested by one agency can be eligible for the program and not go to jail. And yet if you're arrested by Pasadena or the constable, you do go to jail. So I'm just against discrimination. But I'm glad she moved to the middle on marijuana. I think it was for political gain, but it helps people. And so anything that helps people, right on.
And is this your first time? This is your first time running for office?
No, I ran for judge in 1996. I did not prevail. The primary system, especially on the Republican side, where I'd run before, is a real pay-to-play system. I didn't pay, and they didn't let me play. And I ended up thinking that it was a real blessing. I'm glad I didn't pay the people who run that side of the street. I'm glad that I'm running for district attorney. I think I'm an advocate, not a referee, but I've got some great judicial candidates on the ballot with me in my party. I applaud them. I'm very impressed with their credentials and with the passion and the hard work that they've put into this campaign during the last 13 months. So I'm glad to be running for DA and nothing else.
What divisions of the district attorney's office need to be strengthened, and what would you do to strengthen them?
The practice of law has become more and more specialized in the private sector, and that's because it is impossible for a practitioner to stay up to date on all of the latest cases, the technology that's available, and remain competent in all areas of law. So we used to have general practitioners. My dad was one of them. He's one of the last. Same with medicine. You know, there just aren't many Marcus Welbys out there anymore. That's an old TV star name for those people who are under 40. At any rate, there are no general practitioners left. Our DA's office under this administration continues to run the office like general practitioners under this theory that a DA should be able to prosecute any type of criminal offense well. Well, in truth, the DA's office must be specialized. It must become more and more specialized. Intake, the division that accepts charges from police officers who make arrests, has to be strengthened. We need experienced lawyers who understand a clear written policy that is going to be a new policy under a new administration about what is and isn't acceptable. We're going to specialize our case assignments right there at the front door, and that'll save multiple settings for people who have to come to court, both crime victims and the accused, and it'll save taxpayers millions of dollars. So I'm going to strengthen the white collar division, the animal cruelty division, which was disbanded by Ms. Anderson and reassigned into domestic violence. I'm going to specialize, reconstitute the gang division, and I'm going to fully staff these specialty divisions, beef up consumer fraud, white collar, because crime is multifarious in the 21st century. There's so many ways that the law can be violated. Public integrity, our public officials, that shouldn't be done by a baby or inexperienced lawyer. We need people with lifelong judgment in those positions. So public integrity is another one. Civil rights, which is what prosecutes police behavior, that needs some serious looking at, because the public has lost faith that policemen will be held accountable when they cross that line from protecting us to oppressing us.
Thank you.
Thank you so much, Ms. Ogg, for your time. If you wanted to take 60 seconds and talk to the folks at home and tell them why they should vote for you.
I'm Kim Ogg. I'm running for Harris County District Attorney, and I need your help to change the status quo. I have a strategic plan for making Harris County safer while ensuring that no innocent person is wrongly convicted. We need a fair grand jury system. That can be done through leadership by our DA. We need to use taxpayer dollars in a smart way that really helps us be safer, not just puts thousands and thousands of people in jail for minor offenses and cripples our workforce. Please take a look at my website, kimogg.com, for more information about veterans protection, about animal cruelty, about white-collar crime, and the cost that crime itself is having on our community. We can live a better life. I need your help to take charge of the Harris County DA's office. I need your vote. I will be a DA that you can be proud of and whose judgment you can trust.
Thank you so much for your time. Amy, I guess one more time you want to give the folks at home the information?
Sure. The website address for the League of Women Voters of Houston, if you have questions, is www.lwvhouston.org. And our telephone number is 713-784-2923. The county clerk's office is www.harrisvotes.org. Their telephone number is 713-755-6965. And I think this race is one of the hottest in several counties, so we've probably got people tuning in from other counties. So call the Secretary of State's office if you've got questions and you don't live in Harris County. And their website address is www.votetexas.org. Their telephone number is 1-800-252-VOTE. Thank you very much.
And thank you again at home. This concludes the 2014 League of Women Voters Education Fund, Texas and Houston, conversation with the candidates. Good night.